In the professional realm of corporate governance, a critical area of focus is the management of data sharing between corporate affiliates to avoid creating significant privacy landmines. While it is common for large organizations to operate through multiple subsidiaries, each of these entities is typically viewed as a separate legal person under global privacy and data protection laws. Typically, a lack of formal oversight in this area leads to the accidental leakage of personal data across corporate boundaries without a valid legal basis or the necessary transparency for the users involved. What this means is that we must treat internal transfers within a corporate group with the same level of legal and technical rigor that we apply to external third-party vendors. By mastering the governance of affiliate data, you ensure that the entire enterprise remains compliant and that its shared digital assets are protected by a consistent set of professional standards. Before we continue, a quick note. This audio course is a companion to our course companion books. The first book is about the exam and provides detailed information on how to pass it best. The second book is a Kindle-only ebook that contains 1,000 flashcards that can be used on your mobile device or Kindle. Check them both out at cyberauthor.me in the Bare Metal Study Guide series. Affiliate data sharing occurs whenever separate legal entities that exist under the same parent company exchange personal information about customers, employees, or business partners. Even if these companies share the same logo and the same executive leadership, the law often requires each entity to respect the privacy rights of individuals as if they were independent organizations. In practice, this means that a transfer of data from a retail subsidiary to a central marketing division is a formal legal event that must be accounted for in your compliance documentation. Typically, these transfers are driven by the desire to centralize operations, perform joint data analysis, or improve the overall customer experience through personalization. Understanding the legal distinctions between these sister companies is the first step in building a governance framework that can survive a rigorous regulatory audit. A helpful way to develop your oversight in this area is to practice by identifying exactly which of your sister companies or regional affiliates currently receives personal data about your customers or employees. You may find that your human resources department shares payroll data with a central service center or that your sales team uploads customer leads to a shared global database. In practice, these informal data flows often grow organically over time without the knowledge or approval of the legal and privacy teams. Typically, once you have mapped these internal connections, you can begin the work of verifying that each transfer is supported by a clear business purpose and a valid legal justification. This internal audit is a vital exercise for bringing transparency to the often murky world of intercompany data movement. A frequent and potentially costly pitfall in corporate governance is the assumption that sharing data within a corporate family does not require a formal legal agreement or a specific privacy notice. This misconception often stems from the idea that because the entities have a common owner, they also have a common right to all the data collected by any member of the group. In practice, regulators like the Federal Trade Commission, FTC, or the European Data Protection Board, EDPB, view unauthorized internal sharing as a potential violation of the promises made in your public privacy policy. Typically, a failure to document these internal transfers is seen as a lack of accountability and can lead to significant fines and a loss of consumer trust. By treating every affiliate as a distinct partner, you protect the organization from the legal risks of unmanaged data sharing. You can achieve a significant quick win for your governance program by creating a detailed map of the data flows between your specific company and its various business affiliates. This data map should identify what categories of information are being moved, who has access to the data, and the technical methods used to facilitate the transfer, such as an application programming interface, API, or a secure file transfer. In practice, this visual representation serves as a primary tool for identifying high-risk sharing activities and ensuring that each flow is protected by appropriate security controls. Typically, a clear data map makes it much easier to explain your internal practices to a regulator or to respond to an individual's request for access to their personal information. This structured approach brings order and professional clarity to the complex technical landscape of the modern enterprise. Visualize a professional and clear privacy notice that tells your customers exactly which affiliate companies will process their personal data and for what specific business purposes. Transparency is a cornerstone of modern privacy law, and a well-drafted notice ensures that users are not surprised when they receive a marketing email from a sister company or a different brand within your portfolio. In practice, this notice should be easy to find and written in plain language that avoids overly complex legal or technical jargon. Typically, the goal is to provide the user with a no-surprises experience where they feel in control of their information at every stage of their relationship with your brand. This level of openness is essential for building long-term customer loyalty and for meeting the strict transparency requirements of global regulations. In the field of corporate law and compliance, we use the specific term intercompany agreement to describe the legally binding contract that sets the rules for these internal data transfers. This agreement, often referred to as an intra-group data transfer agreement, IGDTA, ensures that every affiliate is held to the same high standards for security, data minimization, and user rights. In practice, the agreement should include specific clauses regarding liability, breach notification, and the technical standards for protecting the shared information. Typically, using a standardized agreement across the entire corporate group ensures a consistent level of protection regardless of which country or region an affiliate is located in. What this means is that you are using a formal legal instrument to create a common law for data protection within your organizational boundaries. Reviewing the privacy policies and security practices of your affiliates is a critical task that ensures they provide the same level of protection for shared data as your own organization does. It is not enough to simply have an agreement. You must have a reasonable assurance that your sister companies are actually capable of fulfilling their contractual and legal obligations. In practice, this might involve conducting periodic mini-audits or requiring your affiliates to provide evidence of their latest security assessments or training logs. Typically, if an affiliate has a significantly weaker security posture than your own, any data you share with them is essentially being moved from a safe environment to a risky one. This ongoing monitoring ensures that the overall integrity of the corporate data ecosystem remains strong and defensible. Imagine the challenging and high-pressure scenario of a regulator's questions if they discovered that you shared sensitive health or financial data with a marketing affiliate without clear and explicit user consent. In many jurisdictions, sharing sensitive information with a different legal entity for marketing purposes requires an opt-in choice that is separate from the standard terms of service. Typically, a regulator will look for proof that the user was fully informed of the sharing and that they made a voluntary and documented decision to allow it. In practice, a failure to meet this high standard can lead to devastating penalties and a public relations crisis that can damage the reputation of the entire corporate family. This visualization highlights why the governance of affiliate data is a high-stakes professional responsibility that requires constant vigilance. You can anchor your entire governance strategy in the fundamental legal principle that each legal entity within a corporate group is ultimately responsible for its own compliance obligations. While a parent company can set the global policy, the individual subsidiary is the one that will be held liable for any failures in how it collects, uses, or shares personal data. In practice, this means that your governance efforts should focus on empowering each affiliate to manage its own risks while adhering to the central standards of the group. Typically, this decentralized approach to responsibility ensures that compliance is not just an administrative task at the headquarters, but a daily operational reality at every level of the business. This commitment to entity-level accountability is what creates a robust and resilient global compliance program. In this lesson, we have covered the legal requirements and the practical technical steps needed to manage data flows across a complex and diverse corporate structure. By establishing a formal framework for affiliate sharing, you are protecting the organization from the legal and reputational landmines that often hide in internal business processes. Typically, the most successful governance programs are those that view their affiliates as trusted but regulated partners who must follow a clear and enforceable set of rules. In practice, this approach ensures that the business can reap the benefits of data sharing such as improved analytics and personalized services without sacrificing the privacy of its users. This integrated approach to intercompany governance is a key differentiator for the modern security and compliance leader. A highly effective technique for maintaining this control is to use a standardized data sharing protocol that ensures consistent privacy protections regardless of which affiliate is involved in the transaction. This protocol should define the minimum security requirements, the mandatory data fields for each type of transfer, and the process for resolving any data subject requests that involve multiple entities. In practice, having a standard way of working reduces the risk of human error and ensures that no affiliate is left to guess what the privacy rules are for a given project. Typically, these protocols are documented in a central governance manual that is accessible to the IT, legal, and business teams across the entire enterprise. What this means is that you are building a scalable and repeatable process for global data management. Proper and disciplined governance of affiliate data protects the entire brand's reputation and prevents the accumulation of regulatory fines across the global enterprise. When an organization can show that its internal sharing is managed with the same rigor as its external partnerships, it demonstrates a high level of professional maturity and a deep respect for individual privacy. In practice, the energy you spend on documenting these flows and agreements today is a direct investment in the long-term stability and legal safety of the company. Typically, mature organizations are those that recognize that their data is a shared corporate asset that must be protected by a common set of values and legal guardrails. This focus on internal governance is what ensures that your organization remain a trusted and responsible leader in the digital economy. This concludes our unit on how to govern data sharing with corporate affiliates without creating privacy landmines that can disrupt your organization's operations and reputation. We have discussed the definition of intercompany sharing, the role of intercompany agreements, and the necessity of mapping data flows and maintaining entity-level accountability across the group. A warm and very practical next step for your own professional growth is to take a moment today and list all the primary corporate affiliates that currently exist within your organizational structure. Once you have your list, consider which of these entities are most likely to receive or share sensitive information with your specific department. Moving forward with this clear picture of your corporate family will help you ensure that every internal data transfer is safe, legal, and fully defensible.
Thanks for listening. For more audio courses, daily newsletters, and more, please visit baremetalcyber.com.